What you're about to see is a textbook example of how confusion, poor communication, and the legal system collide with real consequences. This is State of Texas versus Richard Cantu, a deferred adjudication case that starts as a simple failure to report and spirals into a 4-year prison sentence. At first glance, it sounds straightforward. Probation says he didn't report. But as the hearing unfolds, you'll watch a judge repeatedly slow things down, re-explain basic rights, and try again and again to get a clear yes or no answer from the defendant. And that's where the tension lives. Because deferred adjudication is not a free pass. One wrong move, one misunderstood answer, and the court has the power to flip the switch from probation to prison. Pay close attention to how many chances are given, how carefully the judge explains the stakes, and how quickly things change once the plea becomes final. The big question here isn't just whether he failed to report it, whether he truly understood what he was agreeing to before it was too late.
CR 11554 for the offense of obstruction or retaliation on September 16, 2024 for a period of 3 years. Is that you?
Yeah.
All right, state.
Violation of condition number 4 in Bexar County, Texas. The defendant, Richard Cantu, did then and there fail to report to the supervision officer as directed for the months of August, September 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We would abandon the remainder.
Any objections to the waivers? Did you understand by pleading true to violation of condition 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
True.
No. Are you pleading true to number 4?
Sure.
Do you understand? No. Listen to me. Are you pleading true to violation of condition number 4? Yes or no?
No. Don't know what I mean.
Oh, so this is what it means. The state is saying that you did not report. Do you understand that?
Yes.
Did you report?
No, I couldn't find a big.
Nope. I just want you to answer my questions. All right. So you have just pled true to the fact that you didn't report. Do you understand that? Now, whatever agreement you worked out with the state, I don't have to follow that. Do you understand? I can send you to prison for 10 years. Do you understand? So knowing that I can send you to prison for 10 years and up to 10,000.
This is one of the most uncomfortable moments in the entire hearing, and legally, one of the most important. The judge is trying to establish a knowing and voluntary plea, which is required before the court can accept it. Notice how many times she explains the same thing. Pleading true means admitting the violation, and that admission alone gives the court authority to sentence him to up to 10 years in prison. Yet the defendant keeps wavering. Yes. No, I don't understand. I didn't report. I couldn't find them. From a legal standpoint, this is dangerous territory. Judges are trained to stop proceedings when confusion shows up on the record, because a plea entered without understanding can be challenged later. That's why the judge draws a hard line and ultimately says, we're setting this for a contested. Herein she's protecting the integrity of the process. And here's the question for you watching. Should courts keep slowing down when a defendant is clearly struggling? Or is there a point where responsibility takes over?
So we need a contested hearing. All right. What date for a contested hearing? Failure to report.
I can do the 7th, Judge,
Do you want to do the 7th
or the 9th.
or the 9th? Now it's up to you. If you want to bring it back for another day, that's fine.
We do second.
All right.
15th.
All right. We'll see you back on the 15th. The state will call whatever witnesses they need to call to seek to prove the failure to report. And what I can tell you on failure to reports, usually the person that needs to be called is the probation officer.
It was at this moment that he knew he fucked up.
Is going to come in and say either you reported or you did not.
I did not report. So I know I didn't report to nobody when I got released those 3 times.
So I don't understand why you're not asking my questions.
But to be saying yes, I did not see no one, or no, I never went into the door. I'm saying that I never went to see the probation officer because I never saw him. I never got reported to see him.
Mm-hmm.
I never got his address or his phone number to see.
Mm-hmm.
Yes, I want to move forward with my case. I want to take it to I wanna take it all the way, like guilty and not guilty, I plead guilty. I pay no contest also, but I never saw my probation officer when I got released. I never had ever seen
You want to talk to him some more?
2 very boring minutes later.
This is where everything locks in. When Mr. Cantu comes back and clearly answers yes to pleading true after, the judge once again explains the full consequences. The court finally has what it needs to move forward. And notice the shift. In tone, the confusion is gone. The judge confirms the waiver of appeal, confirms the agreement, and then announces the sentence. 4 years in prison. This is the harsh reality of deferred adjudication. Once it's revoked, the court can immediately enter a felony conviction and impose prison time. There's no trial here, no jury, no dramatic verdict, just a legal switch being flipped. One moment you're on supervision, the next you're being sentenced. This moment shows how fast courtroom outcomes can change once a plea becomes final. And it raises a tough question. Was this outcome inevitable from the start, or could clearer communication earlier have changed everything?
All right. Is that your agreement?
It is, Your Honor.
Mr. Cantu, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will follow your agreement. All right, the court will find violation of condition number 4 true. The court will follow your agreement, find you guilty, revoke, sentence you to 4 years in the prison, give you credit for any time served, take into consideration 2025 PF 43375. There should be no residing in households with minors, no unsupervised contact with minors. I'll state you may be excused. And the therapeutic community. Did you review the document entitled Trial Court Certification of
In the
Defendant?
end, the court follows the plea agreement exactly as presented. Richard Cantu's deferred adjudication is revoked, a felony conviction is entered, and he's sentenced to 4 years in prison with credit for time served. The judge also outlines strict post-conviction conditions, including restrictions involving minors and the permanent loss of firearm rights. This case highlights a critical lesson in the criminal justice system. Probation and deferred adjudication are second chances, but they come with zero room for miscommunication. Failure to report may sound minor, but legally, it's enough to unravel everything. The judge's repeated explanations show the system trying to be fair, but once a clear plea is entered, the outcome becomes unavoidable. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.